When it comes to asbestos exposure, most people know it's dangerous, but fewer people realize that the laws governing asbestos can look very different depending on where you live in the United States. Federal regulations do set the foundation, but individual states often add their own rules, restrictions, and deadlines. If you've been exposed to asbestos, or you work in industries where asbestos could still be present, understanding these state-by-state variations is critical. In this video, we're going to break down exactly how asbestos exposure laws differ across the country, what that means for victims, workers, and companies, and why timing is everything if you're considering legal action. Let's start with the basics. At the federal level, agencies like OSHA, the Occupational Safety and Health Administration, and the EPA, the Environmental Protection Agency, have created nationwide rules to limit exposure to asbestos. These include workplace safety standards, environmental cleanup requirements, and rules for handling asbestos in schools, public buildings, and during demolition. Laws like AHERA, the Asbestos Hazard Emergency Response Act, and NESHAP, the National Emission Standards for Hazardous Air Pollutants, apply in every state. They set minimum safety protocols for handling and removing asbestos and require specific training and certifications for workers. But here's the important part. These are just the minimum standards. Many states go beyond them. For example, California is known for having some of the strictest asbestos regulations in the country. OSHA, along with other state agencies, requires detailed record-keeping, mandatory notifications before asbestos removal, and contractor licensing that goes beyond federal requirements. Abatement records must be kept for 30 years, and strict rules are in place for protecting workers and the public during removal projects. New York also enforces strict requirements. All asbestos abatement contractors must be licensed, and the state requires prior notification before starting any asbestos project. That means you can't just hire someone to start removing asbestos from your home or building without going through the proper state channels. Washington State took a unique approach by banning asbestos in automotive brakes back in 2014. That's an example of a state targeting a specific product where asbestos was still being used. New Jersey is even more aggressive. It's the only state in the country to outright ban the sale and use of asbestos-containing products. That's a step beyond most other states, which still follow the federal rule that allows some limited uses of asbestos. Arizona generally follows federal NESHAP rules, but some counties, like Maricopa and Pima, have additional local laws that tighten asbestos regulations even further. This shows that even within a single state, different regions might enforce stricter asbestos controls. Now let's talk about litigation, because the legal process for asbestos-related claims also varies dramatically by state. The first and most important factor is the statute of limitations. This is the time limit you have to file a lawsuit after being diagnosed with an asbestos-related disease. In most states, the clock starts ticking from the date of diagnosis, not from the date of exposure. But the length of that time limit can be anywhere from 1 year to 6 years depending on the state. California, for instance, has a very short statute of limitations, just 1 year from the time you're diagnosed. California is considered plaintiff-friendly in many respects, but if you miss that 1-year deadline, you lose the right to sue. Texas gives you 2 years, but it has stricter rules on proving causation, which can make cases harder to win. Florida falls somewhere in between, giving victims more time than California, but still requiring substantial medical evidence before a case can move forward. Pennsylvania has its own structured case management procedures that address impairment levels, punitive damages, and even successor liability, which determines how legal responsibility transfers when companies merge or are acquired. Another area where states differ is in how they handle asbestos bankruptcy trusts and transparency rules. Some states, like Ohio and Oklahoma, require plaintiffs to disclose claims they've filed with asbestos trust funds before moving forward with a lawsuit in court. These laws are meant to prevent what's sometimes called double dipping, getting compensation from multiple sources for the same injury. Texas passed similar rules in 2015, and states like Wisconsin have also adopted reforms to increase transparency in asbestos cases. Now let's look at penalties. Violating asbestos regulations can be costly, but the fines vary widely depending on the state. In Kansas, for example, penalties can go up to $5,000 per offense. Hawaii is tougher, with fines up to $10,000 per violation. Some states also have unique rules about premises liability and punitive damages, which can increase the amount of compensation victims can receive if negligence is proven. These differences matter because they shape the legal strategy for both victims and their attorneys. In some states, proving your case might be easier, but you have less time to file. In others, you have more time, but face higher evidentiary standards. If you're a contractor or property owner, you need to know exactly what your state, and sometimes your county, requires in terms of licensing, reporting, and safe removal practices. Ignoring these laws can lead not only to financial penalties, but also to criminal charges in severe cases. It's also worth noting that asbestos cases can cross state lines. For example, if you were exposed in one state but diagnosed in another, or if the company responsible for your exposure is headquartered somewhere else, jurisdictional rules will determine where your case is filed. That's why many asbestos law firms operate nationwide. They can choose the jurisdiction most favorable to the client's case. To recap, asbestos exposure laws vary in three major ways across the United States. First, the regulatory standards for handling, removing, and disposing of asbestos differ from state to state, with some going far beyond federal requirements. Second, litigation rules like statutes of limitations, proof requirements, and bankruptcy trust transparency laws create very different legal landscapes depending on where you live. And third, penalties for violating asbestos laws can range from a few $1,000s to much higher, with some states imposing additional liability rules. If you or someone you know has been exposed to asbestos, the key takeaway is this: don't assume the rules in your state are the same as somewhere else. Federal laws provide a baseline, but the details that really matter, the timelines, the proof you need, the penalties for noncompliance, are determined at the state level. The sooner you understand those laws, the better prepared you'll be to protect your rights, your health, and your financial future.